So even if a party is not performing its obligations, what's the likely liability for that? Is it capped in some way? Uh, are those limitations of liability permissible under your country's governing law? If you're a purchaser and you want to get out of the contract because you no longer need the services, are there termination rights? And the same can apply for a supplier who all of a sudden the contract doesn't make commercial sense because the prices they quoted are now mean they're trading at a loss. And of course, whilst I've noted governing law there as the sort of governing law term in the contract, there will also be the impact of outside legislation. So many countries will have consumer protection provisions which will limit the extent to which you can behave perhaps unfairly with customers. And there'll be other countries will have legislation which imposes force majeure type clauses or deals with frustration of contracts. So even before you really get too far into it, there's a lot of issues that need to be considered just looking at that once you've identified what the initial contract is. And the considerations will be different from the customer perspective and the supplier perspective. Um, so from a customer's perspective, again, first thing, find out whether there's a contract and what does it say, going through those types of issues I've already raised there. Now, as a customer, you may, and I'm not advocating a particular approach here, but some people will take an approach where they may be more lenient on their supplier and not insist on strict legal rights when they wish to, when they perhaps could have. When you do that, you need to be careful. So what's happened in March and April and May, in when COVID-19 is fresh, may may not quite sit well with people when they're sort of reviewing issues later in the year or next year, and it may well be the case that perhaps a leniency that was adopted now may not be something which a party chooses to either stick by or to have carried through indefinitely. What is important is if you wish to um, give some leniency, be sort of commercial perhaps, or flexible in relation to obligations, just appreciate the impact it can have. Most countries will recognize that there can be a waiver of rights. If someone's breached a contract, but you say, look, in the current circumstances, that's fine, just do the best you can, that may constitute a waiver of rights. If you say words to the effect of, we've dealt with you for a long time, we're not gonna sue you over this when we can see that it's not your fault, and then later on you do, that may be seen as a false representation. And most countries' legislations will have provisions dealing with misleading conduct. And you may think to yourself, well, what loss has that supplier suffered just by me saying I wouldn't sue them? And that supplier may well say, well, I had 10 customers I needed to service. I elected not to put my emphasis on servicing you because you said that you wouldn't sue me. Had you actually not made that misrepresentation, then I would have put more emphasis on supplying you and not have breached the contract. So we do need to be careful of what we say, particularly if we're not prepared to stand by that in a few months' time. There's also, in many countries, a concept of estoppel. Now, that's a principle under which a person is legally prevented from asserting something which is contrary to a previous statement. So if you as a customer says, no, that's fine, I know it was due today, but if you can deliver it within 30 days, that will be fine. And then later on, say the supplier relies on that, and later on you wish to depart from that, you may well be stopped from doing that because that supplier has relied on that representation to their detriment. So just be very careful about what compromises you make. And I'm not advocating that you don't make compromises. I think in many cases it's actually probably good for the long-term business operations for you to do so. But just be aware that when you do make a compromise, it can have legal impacts. Document whatever compromise there is so that down the track, it's not being put that you made a bigger compromise than what you originally did. Try to put some time frames around it. If you are prepared to be more lenient now, I would say that limit that to a certain period and reassess it periodically, and make sure the supplier knows that that's what you're doing. Other issues from a customer consideration perspective, of course, force majeure claims will come in there and we'll talk about those later. Have a look at exclusivity commitments. Have you signed up to only purchase goods from that particular supplier? Most times that won't be the case, but if you have a look to see whether there's a right to change if there's delay or inability to perform the services. Some contracts, if they're particularly detailed, will include a no discrimination provision, meaning that that supplier must not treat you any worse than they treat their other customers, or they cannot favour one customer over you. And that can be important, especially if, for instance, you don't have a force majeure clause and your other customers, the supplier's other customers do. Have a look at your termination rights if you need to get out of the contract, and I'll talk about that a little bit later on, but one of the worst things you can do is terminate when you don't actually have a right to, and all of a sudden a supplier who is perhaps worried about their ability to perform their contractual obligations has a claim against you for wrongful termination. And of course, always think about the practical side of things. Even if you can terminate, what solution will that bring for you? If it's one where you actually don't have an obligation to purchase goods at the moment, but more if the supplier can supply, then you receive those goods. Think about, can anyone else supply goods to you? So are you actually going to be able to find someone who can perform the contract better than this supplier? They're obviously practical perspectives for you to take into account. There are some similar issues from a supplier consideration, but I think firstly for a supplier, they need to do that assessment, which they should have been doing, back in March and April, as to what is the impact of COVID-19 on the timeframes, service levels, quality of goods, and then working out, well, what contractual commitments can I no longer meet? And once you've worked that out, you need to look at what rights the contract gives you in that context. And again, we'll look at force majeure later on, but there may be provisions in there that allow you to change rates on the occurrence of a particular event. There may be provisions that allow you to terminate on the occurrence of particular events. In some contracts, there'll be a provision that specifies on the change of laws that impact the performance of services, you can either terminate or renegotiate rates. That would be very relevant, of course, where there are laws now that are impacting. And, thinking about from a sort of lockdown scenario, the laws, that lockdown is generally accompanied by laws making that mandatory. So it is a change of law that people, society was allowed to move freely, and now there are laws in place prohibiting that movement. Do take into account, like I've mentioned before, legislation. You can have the best contractual terms, but if there's legislation in place that requires good faith dealings or prohibits unfair contract terms or has consumer protection provisions, your ability to enforce those terms is going to be limited. Of course, make sure that you're not engaging in any misleading or deceptive statements. I think that one of the number one things we're probably seeing with businesses, and this is more provision of goods and the like, is that their timeframes for delivering goods or providing goods needs to be updated, and there'll be websites out there saying that they'll be dispatched and delivered within 7 days, and if that relies on international air freight, the likelihood of that still being accurate is very low. So make sure that your websites that were designed and drafted in a pre-COVID-19 environment still stand up and are still accurate representations today. I'm sure there'll be courts require with representations generally that reliance on them was reasonable. Now, if it is clear that a consumer should be taking into account the impact of COVID-19 and that the website hasn't been adjusted, that may well be relevant. But if that's not clear, and now we're a couple of months into it, if courts may well think that by now you should have updated those representations, and it's reasonable for a consumer to look at a website now and believe that those timeframes on the website are reflective of COVID-19 timeframes. Just as I mentioned that the customers should document any concessions they give, so should a supplier document any concessions that they receive, because again, you might have someone who you have a good relationship within the customer who gives you that concession and acts in a way that perhaps reflects that long-term relationship. But what happens if that person changes jobs in 6 months' time and the new person in place has a completely different attitude and doesn't wish to provide that concession and disputes whether in fact it was actually provided or not? So be careful. If you get a concession from a customer, one thing to do would just be to ask them, could you put that in an email to me? Or if it's over the phone and they won't do it, then you send an email to them saying, this is what I understood our call to be. Please make sure you send me a reply email if I've misunderstood anything. So these are just some practical considerations dealing with the current environment and your contracts. I do want to get into a little bit on the law about force majeure, but I don't want to overdo it, given that we've probably all become experts in this area of law over the past 6 weeks. What I will say is that force majeure, there's no universal concept of it, even amongst civil law countries compared to common law. It's not like there's one universal concept in civil law countries and one universal concept in common law countries. There is an overriding element or theme in that force majeure as a concept is designed to provide relief to a contracting party from their contractual obligations and liabilities where performance is prevented by some specified event. And we know generally those specified events are going to be things that are outside of their control. Quite often they will be unforeseen, and often there will be a requirement that they act reasonably or try to mitigate the impacts of that event. However, again, that's a generalized statement I've made, and I'll move on to the next slide in a second, but it is very much dependent on, if it is a civil law country, it will be very much dependent on the legislation that implements the sort of force majeure clause or even any additional contract terms the parties have adopted. And in common law countries, it will be very much dependent on the contract term that the parties have adopted and how force majeure clauses have been interpreted by that country's courts. So we've got an international audience and we have a legal concept that is dealt with very differently around the world. Now, when I refer to common law countries, I'm generally referring to a country that has a legal system derived from the English legal system, where the emphasis has been on judge-made law and the doctrine of precedent, whereby those previous judgments can be used to find or create new law. That's very much the case in the contract law area. In common law countries, there's not a lot of legislation dealing with contract law, and it is more based on the past judgments. And in those common law countries, the contract law has not evolved in a way that recognises force majeure just as an implied term or concept that exists independent of the parties agreeing to such a term. It's important to appreciate that in common law countries, there is almost complete freedom of contract. So you can agree to whatever you want. It can be as unfair as you like. And an absence of a force majeure clause in many ways is unfair. Because, for instance, in the absence of a force majeure clause now, many businesses that are impacted by COVID-19 will still have to strictly meet their contractual obligations. But the courts will say, well, that's what the parties agreed. So in those countries, because of the unfairness of how the legal system works in the absence of legislation, parties very often draft a specific force majeure clause. By contrast, civil law countries, they have a much greater role of legislation in those countries. So more terms will be inserted into contracts by legislation than would be the case in common law countries, and very often in these civil law countries they will have legislation that imposes force majeure clauses or the rights relating to force majeure into contracts. Very often those countries will still recognise a specific force majeure clause drafted by the parties, and if you're dealing with a contract that's governed by the law of a civil law country, you really need to look at that legislation to look at the interaction between that legislation and any specific force majeure clause